Hi, everyone, and welcome back to our channel. My name is Ingrid Perez, and I'm an immigration attorney at IVP Immigration Law, where talent meets opportunity in the U.S. We specialize in helping skilled professionals live and work in the United States, navigating the often complex world of U.S. immigration law. Today, I'm excited to dive into one of my favorite visa types, the EB-1A visa for individuals with extraordinary ability. This visa option is fantastic because it can lead to permanent residency. And even better, it allows you to self-petition, meaning you don't need an employer to sponsor you. In this video, I'll walk you through a real case study for a technology professional I represented, illustrating exactly how I won this case for my client. I'm going to call him Mark for the purposes of this video. And by the end of this video, you'll have a solid understanding of the EB-1A process through a compelling real-life example. So before I dive into Mark's story, let's talk a little bit about why technology cases are often very challenging. The world of technology can seem abstract, with much of the work happening in a cloud somewhere. Most technology professionals operate behind the scenes, supporting large companies without receiving public recognition. Unless they are founders, they often lack a strong personal brand. And these professionals, they usually work for large corporations like Amazon, Meta, Microsoft, and others, focusing on advanced technologies such as cloud computing, artificial intelligence, machine learning, and developing complex algorithms. They typically hold titles like software engineers, developers, or solutions architects. This field is enormous, and to succeed with an EB-1A petition, it is crucial to identify a niche and showcase what makes the individual stand out. And that's exactly what I did with my client, Mark. So my client, Mark, has over 20 years of experience in the technology sector, having worked for renowned companies such as Dell and Microsoft. A few years ago, he was hired by a very well-known retailer with an ambitious plan to scale from 300 stores to 6,000 stores across the United States. They understood that to achieve this, they needed to leverage technology effectively, and that's where Mark came into play. As the lead on this transformative project, Mark built a team dedicated to developing the technology infrastructure necessary for such an ambitious expansion. This brings us to the first prong of the EB-1A criteria that I successfully argued. The first prong that I argued was that Mark played a critical role in an organization with a distinguished reputation. As the project leader, Mark's role was essential for the company's growth and success. To support this, we included letters of recommendation from his peers and senior executives that outlined his significant contributions to the project. These testimonials were not just general praises, they highlighted specific instances where Mark's expertise directly influenced the outcome of the project. This illustrated to the immigration authorities that he wasn't just a cog in the machine, he was a vital asset. Next, we addressed the criterion for original contributions of major significance. As I mentioned before, many tech professionals work behind the scenes and don't receive public acknowledgement for their innovations, and typically their intellectual property is owned by their employer. To demonstrate Mark's significant contributions, we crafted a detailed narrative outlining the story of the technology he developed. We explained how this technology led to the retailer's successful expansion, and we provided evidence of its impact, including media coverage that discussed the company's growth. Although the articles didn't mention Mark specifically, they highlighted the transformative technology he had a hand in creating. This leads me to an important point. Testimonials from industry leaders can bridge the gap when public recognition is lacking. We were able to connect media mentions to the company's success back to Mark's contributions through these letters, showing immigration authorities that while he may not have been in the limelight, he was critical to the organization's success. Moreover, Mark began to document his findings in the form of scholarly articles. He authored about 15 articles, several published in very prestigious journals with high impact factor. The citations and recognition he garnered from these publications further demonstrated his expertise and significance in the field. Because of his scholarly articles, Mark became a sought-after expert and was invited to review academic papers for various journals and conferences. This allowed us to argue the criterion of judging the works of others, demonstrating that he was not only a contributor to the field, but also a recognized authority. Mark's ability to review and contribute feedback on academic work solidified his standing in the academic community, reinforcing his status as an extraordinary talent. Additionally, Mark was invited to join several prestigious professional associations that require outstanding achievements for membership. This served as another criterion, we could argue, showcasing that he was recognized by his peers as a leader in the field. Another significant aspect of Mark's profile was an industry award he received for data engineering in his home country. This award was not from a generic program, but a recognized accolade for excellence in his field. It was a testament to his contributions and standing within the industry. And finally, we addressed the high salary criterion, showing that Mark was compensated at a level that reflected his extraordinary abilities. High remuneration is one of the factors that immigration authorities look at when assessing extraordinary ability, and Mark's salary was well above the average for his role. So to summarize, the criteria we argued for Mark's EB-1A petition included awards for excellence in the field, memberships in associations that require outstanding achievements, scholarly articles published in respected journals, judging the works of others through peer reviews, his critical role in a company with a distinguished reputation, original contribution of major significance, his high salary as an indicator of extraordinary skills. Notice what we didn't argue: publications about him, because like many tech professionals, he didn't have any. However, by focusing on his contributions and the evidence available, we built a compelling case and he was approved. And Mark didn't set out to create an EB-1A profile. He became one of the best in his field through his hard work and achievements. That's the key to a successful tech EB-1A petition. And while these cases can be difficult, they are certainly winnable. I enjoy telling my clients' stories, and this is how I told Mark's story. If you think you might qualify for an EB-1A or want to explore other immigration options, feel free to reach out to me. Here at IBP Immigration Law, we have the experience and expertise to help you navigate the complexities of U.S. immigration law. Thank you for watching. Make sure to subscribe for more success stories, and I'll see you next time.